Welcome back to the Texas Coalition on Coerced Debt, Legal Strategies to Address Coerced Debt in Texas, Part 2. My name is Carla Sanchez-Adams, and I'm a managing attorney at Texas Rio Grande Legal Aid. And in this part, we will cover the Fair Credit Reporting Act, or what we affectionately term as FCRA. And so we're going to go in depth into FCRA and basically do an ABCs of what the FCRA is, what it covers, and how you can use it to help victims of identity theft, coerced debt in Texas. So what we'll cover in this presentation is general terms and definitions under FCRA, as well as an overview of the rights and remedies and litigation strategies. So please, please, please use this statute, file lawsuits with this statute because it's very powerful to help consumers and victims of coerced debt to correct their credit reports and their consumer reports. So with that, I will go into the difference and the definitions of credit reports, consumer reports, and all of those fun things that we use. First of all, just so you know, the FCRA was developed as the first privacy law in the US. So what happened was these consumer reporting agencies, and back then Experian, TransUnion, and Equifax were like the only players in the game. They compiled data from consumers and prepared these reports and then sold these reports to lenders who wanted to lend to consumers, all without, us consumers having any say in the process. And so the FCRA said, okay, listen, we need to make sure that all of these reports are accurate and that there are reasonable procedures in place when they prepare these reports. And how can consumers, if they're not accurate, if they have, mistakes, how can consumers fix them? How can they get them to be corrected? Also, how can consumers access the reports, and who else can access them, and how should they have access to it? And then also adverse actions based on consumer reports. So if a consumer is denied credit, denied a job, denied housing, what must the consumer reporting agencies do to comply after that happens, as well as employers or landlords or any lender who uses those reports. So the first term that is one that we use interchangeably, unfortunately, with credit report, but the true term under the statute is consumer report. And it's very, very broad. So it is any written, oral, or other communication by a CRA, consumer reporting agency, about a consumer's creditworthiness, credit standing, credit capacity, character, general reputation, et cetera, et cetera. So this is really broad because it could be anything about my character reputation prepared by a consumer reporting agency and then utilized for determining, credit or insurance. So underwriting for car insurance, for house insurance, whatever kind of life insurance, employment, housing, other permissible purposes, and we'll go into what those permissible purposes are later on in this presentation, but it's very broad. And so, it's not just that TransUnion, Experian, and Equifax credit report that we all know about. It's more broad than that. And it's also kind of circular. So a consumer report is something prepared by a consumer reporting agency. And this is the definition of a consumer reporting agency, or a CRA. It's any person or entity which, for monetary fees, uses interstate commerce to sell these reports, right? And so it says furnishing consumer reports to third parties. So it's a little bit circular because a consumer report is something prepared by a CRA, and the CRA has to do a consumer report. So there's actually a lot of litigation of, is this entity a CRA or not? Are they a consumer reporting agency? And one of the practical tips that I think I have later on in another slide is the CFPB, the Consumer Financial Protection Bureau, regulates a lot of CRAs in employment, tenant screening, the big three. And so if you go to their website, and later on in this presentation, I have a link to it as well, and you just Google consumer reporting agencies, they have a list of all of the consumer reporting agencies that they regulate, including how to get a copy of a report from them, whether they charge you or if it's for free, and then the type of CRA they are. So are they specialty CRA, which I'll get into in a second, or the type of information that it provides. So there are different types of CRAs. The nationwide consumer reporting agencies, those are the ones that everyone says the credit bureaus or the credit agencies or the credit reporting agencies instead of, the nationwide consumer reporting agencies or NCRAs, are Equifax, TransUnion, and Experian. And there are certain provisions in the FCRA that apply only to them. And I'll get to that in a second. And then there's the nationwide specialty CRAs. And those are specific, which there's a slide on this as well, but they are, housing. So for rental application or for employment or for checking and savings accounts or for bank accounts, for underwriting, for public benefits, there's all different kinds. And then there's resellers, and I'll go through each separately. So if you see, here's the link that I was mentioning that you can pull, and that is the NCRA's, discussed this already. And then the specialty consumer reports. So there's also some for medical records and payments. And so for insurance, your general like medical insurance, how many claims you've made, whether somebody wants to extend you insurance or not. And then, there's all of these other types as well under AX that you can look at. And again, this link that you can go to find all of the different ones based on the different types that there are. Now, what a reseller is, and the reason this even matters and why I'm mentioning it is because if you're pulling up a specialty report, so let's say, for example, in the context of housing, if a person is applying to rent a unit, that landlord will generally pull a report from a tenant screening bureau. And I'm going to pick on RealPage for a second. They're a big one here in Texas. So RealPage, they do a background search. They contract out with a third party. Generally, it's LexisNexis to get public record information. So that's including eviction filings, eviction judgments, other liens and judgments. And then they also will purchase a report from Experian or Equifax or TransUnion. And so they're reselling that information that was that TransUnion report or that Experian report. So if you see down here, it says many specialty reporting agencies are actually resellers of the big three. So the big three being Experian, TransUnion, and Equifax. But then they're also a CRA because they themselves compile information, that has that residential tenant history from a previous landlord or other information that they themselves are compiling. One of the things that I'm going to take a step back here on the definition of CRA, which is really important to think about, is that the CRA can be a person. It doesn't have to be a business. So for example, it's not going to cover, I'm just going to pick on, housing again and rental. If a landlord themselves, so I'm a landlord and I am finding out a consumer's background information by doing public record search myself, I am looking at it, their criminal history, and then I'm also looking up court record information. If I'm doing that, I'm not a consumer reporting agency because I'm not selling it to somebody else for profit. I'm just using it myself to determine whether I'm going to lend to you. So the FCRA is not going to apply there. Some other laws may apply, but the FCRA won't. However, if I'm doing this for my lovely study here, and then I sell it using interstate commerce to someone else who will then make a determination about credit, that would cover, the FCRA would cover my activity, even though I'm just a person. So it can be that broad, and it's important to keep that in mind. What basic duty does a consumer reporting agency have, or CRA? So this is the EB. You hear this a lot, people who practice FCRA. The EB is they have the duty to have reasonable procedures in place to assure maximum possible accuracy. The reason this is important is because as we go through in a little bit, the type of information that can appear on a report, one of the things is, for example, obsolescence. So that's how long a bad account can appear on someone's report. So if you have again, credit card with JP Morgan Chase, and it defaulted in the year 2000, that account can no longer appear on your report because an account like that can only appear 7.5 years after the date of delinquency. So clearly 2007, and we're in 2022. So if that is still appearing, that's a violation of this because there weren't reasonable procedures in place to assure the accuracy. There's another provision under 1681C, which deals with the obsolescence, so you can assert it under both. But another big one is when there is, and I'll go through this in more depth in a couple of slides, is if they're mixing you up with another person. So I had this personally when I got married and changed my name. I had a Carla Adams information that was put into my report. It was student loan debt from UT, but I didn't go to UT in undergrad. I went to UT for law school, and I graduated in 2009 from law school, and the debt was from 2012. So they were putting on someone else's information onto my report. So clearly they didn't have these reasonable procedures in place to assure that accuracy. This happens a lot with housing and employment where they don't match dates of birth or social security. They just do name searches. And so this can be a big one for clients. Who provides information to consumer reporting agencies? So specifically to you're going to have this vary by the type of report. So again, if it's an employment report or housing report, but just for the big three, right now I'm going to focus on the big three. You have what are called furnishers. They're the entities that are furnishing or providing the information, and they are the lender. So that's the mortgage company, the student loan servicer. When I say mortgage loan company, mortgage servicer. A debt collector, it could be government agencies for government debt. All of these that you see on here can be reporting and be furnishers. What other information can you find in a report? There's a lot of different types of information that we don't automatically think of. So it will have in different sections, depending on if you get the reports online from annual credit report, the template and formatting may be different than what you get from the mail report. So it may be at the beginning of the report or at the very end, it'll have the different name variations. So for me, it would have Carla L. Sanchez, Carla Leticia Sanchez, Carla L. Sanchez Adams, Carla Sanchez Adams, Carla Sanchez. So it'll have all these variations of my name because of depending on what name I used when I applied for a credit card or when I rented a unit, which name did I use? So you're going to have name variations. So it's going to be important for victims of coerced debt or ID theft if they never use. So I've had clients who never use their maiden name. For example, they moved to the United States when they got married to their abuser. And so all of their information after that was under their married name. So if it's under their maiden name, then for them, that was a red flag that their abuser was doing that. So you want to, make sure that all the information there, or even if they're misspelling your name, because that could be a reason why they're adding someone else's information onto your report. So if you're James Sanchez with a Z, but it's showing Sanchez with an S, and you find information that's not on your report, then it's important to dispute that name variation. Dates of birth, social security numbers. We have had clients who've had their brother's social security number on their report and then their brother's information on the report. So it's important to dispute that information. Addresses as well. So again, if they're ID theft victim, you don't want the identity thief's information, their address on the report, because then someone will try to reach them at that address and provide information there. Same with telephone numbers. Sometimes they include employment information, the big three. So, a lot with some of my clients, it says no employment information found, even though they have been employed. And sometimes it will have like, oh, they worked for this independent school district as, a janitor or whatever. So it'll have that information on there. Bankruptcies will be on there. Public records. So it used to be before, oh my goodness, I think this is 2013, but I could be wrong. Before that date, there was a big settlement with the attorney generals about this in public record information, like judgments that were appearing on credit reports that did not belong to consumers. And that was again because of what I mentioned earlier, they wouldn't match social security numbers or date of birth, just names. So I had a client, for example, I'm going to change their name, but they were Michael Lopez. And then they were, and then somebody else who was Micaela Lopez's information appeared on their report. And they lived in the same apartment complex, but two different units. And so there was an eviction judgment for Micaela Lopez that was appearing on the Michael Lopez's report that should not have appeared because they didn't match the social or the date of birth, just similar names. So that was a huge problem for them. So they stopped putting public records on the big three credit reports, but you're still going to find these on the tenant screening bureaus for rental, employment, background screening companies for employment. So it's important to keep, an eye out for those, especially in the context of criminal records. And I think I may discuss that later on, but if not, that's another problem with reporting convictions when they're really just arrests. Or, there's a lot of problems with reporting somebody else's criminal information on your report because they have similar names. And then, of course, the one that I highlighted up here, the monetary information. So these are called trade lines on the reports. And so generally it'll have the name of the furnisher. So, if it's a debt collection account, it'll say Portfolio Recovery and Associates. It's one, and it won't have the name of the original creditor necessarily. Some of the CRAs do put that, others don't. So you sometimes have to figure it out because they'll say reported balance. And so, in collection since or when the account was open, and then you have to do a little bit of sleuthing and go back up the report and see, okay, they're saying it's for $383. What other account appears for, delinquent and, that was charged off for $383, and figure it out that way. But generally, if the furnisher is an original creditor, it'll say, Wells Fargo, account opened on 9/1 of 2009, and then it'll have all the record history from when it opened until when it closed. So it'll say, always, if it's a good account and account in good standing, it'll say, always paid, closed, never late. So it's like, and that will stay on your report always. It won't come off. It only comes off if it's bad, an adverse or negative account where, okay, open in 2009, 9/1 of 29. And then in 9/1 of 2016, they were 30 days late, then 60 days late, then 120 days late, and then charged off. It'll generally say that, and then it'll report that balance. And so if it was in 2016 when the delinquency occurred, then you have to calculate 7.5 years from that September of 2016 to when that report, that account will stay on a report. So 2023, at the end of 2024, if you add the half months, around then is when it will come off. With the specialty reports, I went through these already, so I won't take a ton of time, but with tenant screening, in addition to the big three report, it'll have tenant history, and I talked about evictions, which is a problem, in criminal history. With employment screening, it'll have employment history, licenses. So if they're work for a particular employer that needs license, it'll have that license history, criminal history, and civil suit judgments as well. And so I talked about these. I'm going to skip it. Other terms that are important, I mentioned trade line already. The file versus the report is important to know because every single consumer has a right to access their file, and the file is bigger than a report. The way we describe report in the FCRA community is a snapshot in time, right? So if I get my report today, it's going to show the accounts that I have as of, generally they're updated every 30 days. I'm talking about the big three. So it likely, if I made a payment today on, one of my credit card accounts, it's not going to be updated today. It's going to show what was reported, the last time it was reported, which could have been, like 2 weeks ago or a week ago, depending on when they updated it. But it's a snapshot in time. The file has everything. So as I mentioned, the report cannot have bad delinquent information after 7.5 years, right? The exception to that, and I should have mentioned there's an exception, is criminal conviction information will stay on reports forever. They won't ever come off. Arrests come off after 7 years, not the one half is only for credit accounts. And then if you're applying for a job that pays you more than $75,000, or if you are applying for a mortgage that's more than $150,000, then those bad accounts can also appear. But the file has all of your history. So since I was 18 and took out a credit card, it'll have all of that from till now that I'm 40. It'll have all of my information in the file, although all of that may not appear in my report for the reasons that I stated before. And so I can access my report. I can access my file. I can request that they give me a copy of my file to find out everything that's in there. The report is what I ask for, that I get the right to once a year for free, or once every 12 months. And then the credit score is not the same as a credit report. So oftentimes clients are like, yeah, I got my credit score. And I'm like, but I'm asking you for your credit report. The score, there's so many different scoring companies out there. So you have FICO, the most common, which is Fair Isaacs Corporation, from up to 800. And so, 560, 720, whatever, that's your score. There's Vantage Score, there's all different types of credit scores, but that doesn't give you any information about what's in your report. And what you need to know is what's in the report. And the score is based on information in the report. So, and they have different algorithms, like how much credit you've had over, what's your oldest credit account? How many accounts do you have open? What is the balance and available credit based on all of the ones that you have? Have you had inquiries, which I'll talk to in a second? How many hard inquiries have you had? All of those will impact your credit score. And then adverse actions is when you're either denied credit or housing or a job, or you're given credit or housing, but with increased interest rate or a higher deposit, security deposit for that rental unit because of you're considered a risk because of information in your credit report. So those are all adverse actions. And so when we talk about that, that's what the term means. So who can access reports? I talked about what reports are, what's in reports, who furnishes the information. Now who can see these reports? So of course, consumers, you have a right to see your report. But then there's third parties or users of reports who, as I mentioned beforehand, have to have a permissible purpose under 1681B. So these, when they access the report, those are called inquiries or pulls or access. So there's hard pulls or soft pulls, or hard inquiries or soft inquiries, promotional inquiries. And so I'll talk through so with a hard inquiry, it's basically that is, you've given someone permission to view your report for the purpose of extending you credit. So if you go and apply for a car loan and you're, say you go to Bob's Used Auto Sales and they're like, okay, well, let's see if we can get you financing. Can we pull your credit? That's going to be a hard inquiry. That's hard. A soft is there are like account review inquiries, for example. So that's if I currently have a JP Morgan Chase credit card, they can access my report as much as they want to. Generally, they access it every month. And it's just called an account review inquiry. They're just checking to see that I'm paying my bills, I guess. So, and then there's promotional. So that's often, they don't have access to your full report, but that's like when you get those, credit offers in the mail, those are promotional offers. They get your information from the CRAs. So the CRAs will sell these lists of consumers, and so it'll be a pre-screen list of people who would qualify, for example. So the consumer's right, again, I mentioned this before, with the big three every 12 months. Then you also can get them free if you've had an adverse action within 60 days. So this is super important. If someone's been denied housing, then generally they have to get an adverse action notice from their landlord saying you were denied housing because of something in your credit report, or in your background file. They use different terms. Here's the company that was used, and you have the right to get a free copy of that report that we used, but it has to be within 60 days of that adverse action. Otherwise, you may have to pay. And then, if the consumer says that they're unemployed, but they intend to apply for employment, or if they're on public assistance, or they think they're fraud, then they can also access that report for free from the big three, or from any of the CRAs. And again, here's that link of how you can request it. So you can see if your client is planning to apply for housing or a job, they may want to request a free copy of the reports from some of the CRAs that are in this list. Other types of permissible purpose, or, again, I mentioned this, a written request, if they, wanted to get credit in connection with a credit transaction. So this is the one that I talked about already. That was, an account review inquiry. Employment purposes. So we talked about this, a court order. So that's important. A lot of times, if you're helping a survivor in the context of a divorce, for example, you can request a court order that the other party provide their credit report, the abuser, to see if there's any information on there that they're hiding from the client. And so that can also be a powerful tool. Child support agency or a government issued license, they all can access the consumer reports. So now I'm going to get into kind of the meat of the problems that we see with clients and credit reports, and then what rights and remedies they have under the statute. So we talked about inaccuracy, not updating accounts or public records. Talked about this obsolescence already, which is the old adverse accounts or adverse information under 1681C. So I'm not going to get into that more. Bankruptcy, another problem is if a consumer's already had a bankruptcy and then they don't report it. So it should be reported under the trade line as discharged in bankruptcy or something like that. Those aren't great cases to bring, but that is an inaccuracy that you should dispute if it's there. Payment history. So that, I don't see it a lot from our clients for many reasons, but it can happen to people if they've actually paid something and it's not reported as being paid accurately, then that is definitely something you would want to dispute. Public information that should not appear. We talked about that already, a judgment that's not theirs, criminal records that aren't theirs. And so when that information is inaccurate, the right that a consumer has is to dispute that information. It triggers the 1681I process, which is called reinvestigation. Why it's called reinvestigation, I don't know. It should just be called investigation, but that's what it's called. So the consumer has to write. I recommend the consumer writing a letter. You could do this online. Problem is, if you do it online, generally what I have found is consumers will go to like Equifax and try to start a dispute, and then you agree to an arbitration and you sign up for other services. So it's not super helpful to do it online, especially because you want to have a paper trail. Also, same with the phone. You can start it over the phone, but always follow up in writing. And you want to say why you're disputing the information, why it's inaccurate. So you're going to say, hey, Equifax, this account shouldn't, is inaccurate because I already paid it, or it's older than 7.5 years, or it was already discharged in bankruptcy, or whatever the reason is. You have to identify the information that's inaccurate, why it's inaccurate, and send supporting documentation. Then you send that over to the CRA. They will then send it over to the furnisher. So if you're disputing multiple accounts, then they're going to send it to all of the different lenders or furnishers. Then they investigate it, send it back to the CRA, and the CRA will either agree with the furnisher and verify the account. The furnishers generally will just say, yep, it's the same person. Yep, this information is accurate. We verify this. So the CRA will verify it. They'll delete it if it's inaccurate, or and then they have to let you know, or they'll update it. So if it was like, if the information was inaccurate, so you did the payment history is wrong, they'll update it so that the payment history is right. So they're not going to delete the account, and they're not going to verify the way it was. They're going to update it. So that's generally how it's resolved. But for purposes of our client, and I'll get through this later, with identity theft, when you're disputing the account as identity theft is like, this isn't mine, I never took it out, or let's say it's coerced debt, because it can be treated as identity theft in Texas, you can still say that and have a copy of that 521 order, or have a copy of your police report or the FTC identity theft report saying, these accounts aren't mine. I'm a victim of identity theft. This information, these names aren't mine. These addresses aren't mine. These telephone numbers aren't mine. Please remove them, investigate and delete them. And generally in those cases, what happens is when they send them to the furnisher, because it's the same, the client's name is the same, the addresses are often the same because the victim was living with the abuser and they use that address. The social security number is the same. The date of birth is the same. They're going to say, we verify this. And so that is a violation if there was no reasonable investigation. If they didn't actually look at the dispute and say, you're going to find that this information is all the same, but it's not me, and here's my court order, or here's my police report, then you can have a claim against the furnisher for not doing a reasonable investigation. And you can also do a claim against the CRA for not doing a reasonable investigation under I. So I'll get into there's other remedies for identity theft as well that I'll get into in a second. But basically what happens is after that dispute, within 30 days, the CRA sends the results. And then they also, if they delete it later on, and I have seen this happen, they can reinsert the information, but they have to notify the consumer in writing that it's been reinserted, and then you can still dispute it again. So again, here's the kind of the reinvestigation, the results. They also should, in our dispute letter, we say please send me a copy of the updated report after the investigation. So they're supposed to send them a copy of the revised consumer report. Often they don't, they just send like they basically send, here's how we updated it. And let's like, I guess it looks like a picture of, or a screenshot of their computer system with like the trade line. That's not sufficient. They should give you the whole report. And we have asserted in lawsuits that their failure to do so, violated I. So this is the S2, S-2. This is the only part of the FCRA that deals with furnishers that has a private remedy. So that means you can only sue the furnishers under the FCRA under this part, which is the reinvestigation part. So again, here you see it says the investigation must be reasonable and look at the merits of the dispute. So it's for those of you that do Fair Debt Collection Practices Act, which is that FDCPA, there's a section of this FDCPA, which we'll get to in part 3 of the series, that talks about the G notice, which is the validation, where it's like a consumer disputes it and then they have to investigate it. It's called validation. This under the FCRA is a higher standard. And so they really do have to investigate, and they often do not. So this is if you're going to be suing furnishers who are not complying with the FCRA and not saying, yes, this is identity theft, remove this, this would be the section of the FCRA you're going to sue them under. So possible claims that we discussed, this is just a summary, is that 1681C or even EB, when the information is old and shouldn't be on there. The EB, failure to maintain reasonable procedures to assure maximum possible accuracy. So that's when either there's a merged file or a mixed file, somebody else's information is on my report, or it's, that's a big one. Reinvestigation, so I dispute it, you didn't actually investigate it, it's still on there. So the I is for the CRA, and the S-2B is for the furnisher. Now, the FCRA provides specific rights to ID theft victims. So, this is, if your eyes have glazed over because I've given you a lot of information, perk up, pay attention, because this is, this is the meat of ID theft for coerced debt victims. So the first one, which is really strong, is a block. Then there's the security freeze and the fraud alerts. So the block, what is that? The block is different than a dispute. The block is is only available to ID theft victims. You have to have a copy of what's called an identity theft report. It's defined in the statute, and then the regs define the statute as well. But I'm sorry, not the statute, the identity theft report. But essentially, it's a police report, that 521 order, the FTC identity theft affidavit. All of those can be an identity theft report. So you have to have one of those to request a block. And then the block, what it does is it doesn't remove the information from a consumer's file. Remember, I talked about the file versus the report, but it blocks that information from appearing on a report. When you dispute it under I, you're requesting they delete that information because that information should have never been in the file, should have never appear on the report. So it's a little different, the deletion versus the block. Now the block is the CRA's responsibility solely. So it's just Experian, TransUnion, Equifax who are making this determination. They're seeing, okay, this person has this identity theft report. They're saying this information isn't there. Check, I'm going to block it. They still notify the furnisher of the information, but the furnisher doesn't really have a say-so as to whether that's blocked or not. But with the I, that whole dispute part that I talked about, that is the CRA has to rely on the furnisher to some degree, because they're saying, yep, it's theirs. No, it's not theirs. Delete, verify, update. So you can, a victim can either just request a block, or I have done both where I request the deletion and the block. So block it now because it's faster. It has to be done within 5 days of them receiving it. And you can still investigate. That's 30 days. Keep doing that. And then, so I talked about this, but these are the different types of things that say the regs say can be an identity theft report sufficient. So report to local DA, FBI Internet Crimes Report. If the theft was done by US mail, US Postal Inspection Service report, all of these can qualify, and court orders too. So that's the 521 order will be here. Okay, so aside from that block, which is super important and super powerful, there's other things that the FCRA gives identity theft victims. protections, and some of these I find are kind of worthless, but I'm going to mention them anyway. That's my editorial comment for the day. The fraud alerts, there's short-term and extended. The short-term is 1 year. It's free. You don't have to pay for it. You don't have to have a police report or an identity theft report. You can just suspect that you're a victim of identity theft. And you can, you don't have to request it from all three. So if I say, hey, Equifax, I think I'm a victim of identity theft, can you put a short-term fraud alert? They then have to notify the other two consumer reporting agencies, Experian and TransUnion. And so they all put that short-term fraud alert. And you see here, they have to tell you that you have a right to request a copy of the report and then provide it within 3 days. The challenge with the short-term fraud alert, which is similar with the extended fraud alert, is that, in theory, it says no new credit extended if the short-term fraud alert is on your report. So that means that what the alert does is, if I'm a lender pulling your information and pulling your report and I see the short-term fraud alert, in theory, I'm supposed to be like, oh, let me make sure that you're the person who they say they are. But the problem is that, but they're supposed to have reasonable policies and procedures to make sure that you are who you say you are. But what's exempted from this is credit cards. So they don't have to do that if they're a credit card, which is really dumb, because that's where most of the identity theft happens in coerced debt. So because of that, it's not super strong. And, if the consumer specifies, so if you're going to request this, you write in there, here's where the potential lenders need to contact me: email, phone number, address. Obviously, phone number is the best one. The extended is the same, except it's for 7 years instead of 1. It includes this 5 years, this provision that you won't be included in a list of offers for credit or insurance that I had mentioned. When you get in the mail these offers of credit, you wouldn't be on that pre-screen list for 5 years. Same, you can, you only have to ask for it from one of the CRAs for them to tell the others. But, and then you get 2 free credit reports annually as opposed to just 1. But the problem is that you have to have an identity theft report to get the extended fraud alert. So that means you have to have either the police report, the FTC identity theft report, or that 521. And then the other thing is, again, similar to with the short term, there's open-end credit accounts are exempted from this. So again, that means credit cards. It doesn't really prevent credit cards from being opened under your name. Here, they are supposed to contact you in person if there's an extended fraud alert on your file, but you have to give them that telephone number or reasonable contact method. The next is the security freeze or the credit freeze. It's, people use the vernacular interchangeably. It's security freeze in the statute, but people say credit freeze. And it is much stronger. And it's something that I do recommend to victims of coerced debt who fear that there's going to be ongoing theft from their abuser. It's strong because it basically freezes access to the reports. Like, nobody can get new credit. That includes the survivor. So if the survivor needs new credit, she would either have to temporarily lift the freeze, and you can actually request that, say, like, call them and say, I want it lifted for 7 days while they go shop around for a car or for housing, or in order to be able to do that. But, as you see here, that doesn't mean that you can't get your report. Like, I can still get a copy of my report, even though there's a security freeze. Existing account creditors can still get it. And then, sorry, I think it's in the next slide, maybe not. But then also, it should be on this slide, but it's not. But if you apply for housing, or if you apply for employment, the freeze won't prevent them from getting a report. So that's important, right? Because if I'm trying to get a job or housing, I don't want to have to continue to lift the freeze. It's only if I'm trying to get a car or trying to do a mortgage or something like that, where that freeze would prevent me from doing so unless I lift it. And what happens is, this one you do have to request from each individual CRA. So it's right there. and you can go, the links are here to where you can get one if you do it online. There's also their phone numbers are on there, so you can call and do it more quickly. What happens is that they have to send you in writing, we've put a security freeze, here's your PIN, and you will need that PIN to lift the freeze. So it's absolutely important that the consumer, the victim of coerced debt, gets that letter and keeps that PIN safe. And it's also, the security freeze, it's great because it's free. You don't have to pay for it. In the past, you had to pay for it. That's no longer the case. Okay, deep breath. Now, what are the possible claims under the FCRA for victims of coerced debt or identity theft? So the first one, of course, is if they don't block. This is against the Consumer Reporting Agency. They don't block it under C-2. If they don't place an alert, either the extended alert or the initial, or even the security freeze, that's under C-1. If you dispute as well as request the block, that reinvestigation that I mentioned earlier, that's the I against the CRA, or the S-2 against the furnisher if you did request the deletion and when you disputed it. I've been mentioning this a lot during this presentation. I will clarify it again, the mixed merged file issue. So there's a distinction between a mixed and merged file in the mind of practitioners who do FCRA. A mixed file is essentially, again, I had mentioned that I am Carla Sanchez Adams. Carla Adams's information appeared on my report. They mixed her with me. But that's different than a merge. So there's two different people. They recognize there's two different people. They have a file for Carla Adams. They have a file for me, and they put some of her information on mine. That's mixed. A merged is one person. So they merged two people into one. So they should have two separate files for people, but they make a mistake and it's as if one of them doesn't exist. Only this one file exists for this person, and that happens with people with common names, so like John Smith. So two John Smiths, one's in Indiana, one's in Florida, and they're supposed to be two separate people, but they merged them as one. And so the problem here, the claims that you could have for that is you don't even have to send a dispute to have an EB claim. That's the failure to maintain the reasonable procedures in place to assure maximum possible accuracy. So if they just automatically mixed or merged someone, like that's their bad. They messed it up horribly. The CRA does. So you could sue them for that. The I is when so they messed it up and then you disputed it and they still didn't fix it. So you would have both of those claims. You'd have an I claim for the bad investigation and the EB claim for their policies and procedures. Right now, you can press pause if you want to go get some coffee, some water, come back and we'll talk about this damages and statute of limitations. So this is the actual practical nuts and bolts of litigating under the FCRA. So we talked about these claims against the CRAs, right? These are just against TransUnion, Experian, and Equifax, or against, RealPage, HireRight, Check Systems, the specialty consumer reporting agencies. So that's the EB failure to have reasonable procedures in place to assure maximum possible accuracy. So that's, bad public record data, bad criminal information that shouldn't be on there. So that can be things that were subject to expunctions or non-disclosures that are appearing and shouldn't appear. That's an EB claim. The mixed merge file, that's an EB claim. Then you have the I claim against the CRA for not the reinvestigation failures, for not properly doing the investigation. The G, failure to disclose a consumer's file. So I said that the consumers have a right to access their file and get a copy of their report. That's the G failure. C is that old information, the obsolescence information. And again, if negligent in maintaining the reasonable procedures to avoid that, that's the EA. And then K is, this is specific, I'm not going to go into it a ton, but it's against them for adverse public information for employment purposes. And then we have against users. So these aren't the furnishers, but these are users. So there's the B claim, which is the impermissible purpose. So that would be in identity theft cases, right? If let's say Capital One knew the abusive ex was taking out a auto loan and put the the survivor as a cosigner, and the survivor wasn't there. And so this person goes and they go to Cap One and say, I want an auto loan. Yeah, this person consents, but they never actually have that person's consent to pull their report. That's an impermissible pull. So you could sue them for that. Against the furnishers, we already mentioned there was no private remedy against them unless it's for failure to do the reasonable investigation under 1681 S-2B. There's no private remedy there's a provision under the FCRA, which is 1681M, that deals with the adverse action notices that I mentioned before. So that's when you are denied credit, housing, employment, et cetera, because of something in your report. By law, under the FCRA, they're supposed to give you an adverse action notice that says you were denied because of information in a report. Here's the company we used. Here's the right to request a free report within 60 days. It can be written, it can be oral, which is problematic, but it can be. And so failure to do so, you would think I could sue them for that. Well, we can't. The attorney generals can, so there's still a remedy under it, but there's no private remedy. So you can't sue for that. The damages under the FCRA depend on whether you can prove willfulness or negligence. Willful is actual or damages. So, how were they harmed? And this is really important in litigation in light of recent Supreme Court decisions, TransUnion versus Ramirez, as well as Espokio versus Robbins, of having to prove just standing in Article 3 standing in federal court. And so the question is, how were they harmed? How were they damaged? So you really want to plead how they were damaged. Were they denied credit because of this information? That's going to be, in the eyes of the credit reporting agencies and furnishers, that is a higher damages case because they were denied credit. But certainly if they were not, the issue is that how were they harmed? A lot of our clients suffer intense emotional distress damages, right? Especially in the context of coerced debt. Every time this happened, I was re-triggered. I remembered all of the abuse that happened. Nobody believed me. Like when I reported the violence to the police department, they didn't want to make a police report. And when I reported the ID theft, they didn't want to take me seriously either. And they accused me of a crime. And I'm saying all of this because this actually happened to one of my clients. So every time I disputed the information with the CRAs and the furnishers, and they kept confirming that it was mine, it was like nobody believes me. And I was victimized all over again. So you can develop damages that way. The issue is with one of the Ramirez cases, one of the issues is on harm is publication. So it's that if a tree falls in the middle of the forest and nobody hears it, did it really fall? It's comparable with this. So if there was bad information in a report, but nobody saw it, was that person actually harmed? So for these cases, you really do want to say, yes, somebody saw it. Somebody, whether it was the credit denial, housing denial or whatever, or if it was just that they pulled her report and they gave her credit, but it was higher than it should have been, or whatever it is, you want to, somebody saw the report and was the client was damaged as a result. So those are damages. And then you get court costs and attorney's fees and punitive damages as well, which is important, we're punishing you because you're a bad actor. These are the high damages from jury trials. And then negligence under O is just, you don't get the punitives. You just get actual damages, court costs, and attorney's fees. Each failure is a separate violation. So each time they didn't conduct a reasonable investigation is a separate violation. Each time, we disputed it and didn't fix it, that's a separate violation. I talked about this already as far as damages, the injury, in fact, at the bottom here that you see, those cases I spoke about. But the other thing is, how many times did you dispute? You can file, like I said before, an EB, failure to reasonable procedures in place to assure maximum possible accuracy without a dispute. So your client applies for a job or housing, they're denied because of criminal background information that isn't theirs, or an eviction that wasn't theirs, or whatever that wasn't theirs. You could file a claim. But if it was ID theft, so if it was accounts that were taken out by the abuser, there was no way that that the CRA would have known unless she first disputes it. So you do have to dispute that first. They have to do a reinvestigation. And so you could file a suit based on they didn't fix it the first time. It took twice, but the more amount of disputes that you have, the better it is as far as a case on liability and willfulness and all of those things. Other credit history is a consideration. So, if you do have a client who has like 12 accounts on their credit report, 6 of them were ID theft, coerced debt, and then the other 6 are hers, but they're all delinquent. The question is like, well, would she have been denied credit anyway because she had really bad accounts? So that's not determinative of filing suit or damages, but it's a factor, and you should think about that and consider it because it's going to be an argument the defense brings up. And so it is specifically in causation. So they're going to say, well, our mess up didn't cause their harm. So you really have to investigate that. And then, we're talking more nuts and bolts, like if you're actually filing a suit, you're taking it to trial, it's possible that you would need an expert on credit reputation damage. But the client can still testify as to how it impacted them for that damage, right? For the emotional impact damage. Or if they lost the job, how much money they would have made, they can testify as to that. With punitive damages that we discussed, that's the willfulness. And so the standard for that is showing under Save Code that the plaintiff knew or should have known that the conduct violated the statute. So this is where, if they've been sued on this many times before, in addition, if you've sued them on this many times before, that goes to willful. You can also see enforcement actions from the CFPB or FTC if there's consent decrees and they are not supposed to do this and they're continuing to do that, that would be willful. So the statute of limitations on this is 2 years from when it happened, when the client discovered it, or 5 years from when it occurs. Like that's the maximum, right? So it can't be like, oh, I found out about it, but it happened more than 5 years ago. If you're within the 2 years, but not the 5, you have to be one or the other. And again, because every new violation is a new cause of action, I have had clients, for example, who first discovered it and we were outside statute of limitations, but she kept continuing to dispute. So the ones that were within the statute of limitations, we asserted those were the violations. And then we just used the previous disputes as supporting evidence of their behavior and their willfulness. Here are some resources. The National Consumer Law Center, who I will be employed at in a couple of weeks. They have a fair credit reporting manual, and that has a ton of case law. So if there's a question and you're not sure how a court's going to rule on it, that's where you want to go. The National Associations for Consumer Advocates I serve on the board currently, and one of the fabulous things that it does is it creates a community of consumer advocates. So if you're not a NACA member, I highly suggest you join. There's listservs where we're constantly exchanging, like, how's this judge or how's this mediator, or have you had problems deposing this witness? In the FCRA context is extremely helpful, like past transcripts, things of the like, as well as getting co-counseling, connections. So I've co-counseled with private attorneys who I've met through NACA. And then there's the CFPB, who they do sue CRAs a lot. And so they do a lot of that based on our complaint. So you can file a complaint with them, and that doesn't bar you from also filing a lawsuit. So I highly suggest you do that. And finally, if you have any questions, here's how you can contact the Texas Coalition on Coerced Debt. And here is our Gmail information, as well as our toolkit that goes into, has sample dispute letters under the FCRA. So you can go to financialabusehelp.org and look at some of those. Thanks.